Good evening, this is John Milburn for Laws 11062. This is Contract B. We're into week 12, our final week, and we have the examination soon. So good luck with the work that you're doing in preparing for the examination. And this week we're going to continue at the start with a revision of the material for this unit. So by the time we reached week 5, you'll recall we got to illegality. So what are the consequences of an illegal contract? The important point here is to note that it goes beyond the usual contractual notion of simply being declared void. And it all comes about as a result of a policy consideration. The courts will not generally assist someone in acting upon something that was immoral or illegal, and the authority for that is Holman and Johnson. So if you just joined us, we're dealing with week 5, illegality, chapter 18 in your text. The principle Holman and Johnson, courts don't come to the assistance of those that have acted on an immoral or illegal act. So when it's a contract declared void, the parties, the courts attempt to put the parties back into their original position. It goes a little beyond that with illegal contracts. There's a situation where the money or property transferred is generally not recoverable in restitution. So we need to consider contracts that are void under statute. So the case to think of there, the leading case, the one that you want to cite, is Nelson and Nelson. So there are 3 bases upon which a contract might be illegal under statute. It's express, it's implied, or there is some association of illegal purpose, generally as a result of entering into the contract. So contracts void under statute, the case to consider there, Yango Pastoral and First Chicago, Australia. 4 issues. Number 1, if the contract is to do something which the statute forbids. Number 2, if the contract itself is implied or expressly prohibited by statute. Number 3, if the contract is to put into effect a purpose that is unlawful. Or number 4, if the contract is to be performed in a way that is prohibited under statute. And section 64 of the ACL is the statutory provision that you want to consider in that regard. Okay, so the key point when you're looking at illegality is that contracts may be void in different ways as a result of illegality. The consequences may go beyond that which is usually associated with, if you like, standard or garden variety void contracts. But when you're considering the question of whether a contract is illegal or not, don't overreach. In other words, a contract will not, a statute will not necessarily make a contract void by implication in certain circumstances. So if, for example, a statute requires the payment of, we don't call it stamp duty anymore, but you know what I mean, transaction duty, stamp duty in the old terminology for a contract, then without payment of that stamp duty, which is an illegal act, the contract wouldn't necessarily be void. It may be that there's a penalty provision upon the party that obliges them to pay the stamp duty, but that in itself won't necessarily void the contract. So it becomes a question of fine lines in that area. Let's move on to week 6, discharge by performance or agreement, chapters 21 and 19, or 19 and 21 of your text. So you'll recall that we dealt with issues around termination of a contract by performance or agreement. And when the parties have performed the contract, then clearly it comes to an end. So therefore, it's discharged by performance, isn't it? Likewise, it may be that the parties agree. It's not completed, but we agree that it's come to an end by this doctrine of agreement. But now let's look at some of the grey areas. And for example, termination of a contract by performance. What if it's performed but not performed well? How do we determine what is performance? And are there rules that relate to the obligations on the other side? The one that's suggesting that the other party failed to perform the contract in a proper manner. So looking at it from the perspective, if, for want of a better term, the innocent party, remember that generally the courts will want to know that that innocent party was ready, willing and able to perform. So the courts will consider in equitable principles whether that party has a valid claim, because essentially they were blameless and the other party was to blame. The case to remember in terms of the issue of ready, willing and able to perform is McDonald against Denny's Lascelles. We talked about that, I think, last week, 1933, 48 CLR 457. When it comes to performance, we need to then consider another doctrine, and that is this doctrine of exact performance as against substantial performance. And that means considering issues to do with entire contracts versus severable or divisible contracts. So can anyone tell me the leading case when it comes to entire contracts? What's the case that comes to mind that I'd expect you to cite in an exam situation if the argument is this is an entire contract and even a minor failure is enough to relieve the other party from their obligation under that contract? Any thoughts? Very good, Nancy. You're first in with the correct answer, at least the one I was thinking of, Cutter and Powell. So if you're thinking of entire contracts, think in terms of exact performance. Entire contracts, the principles are very closely related. Think in terms of Cutter and Powell. Now, the concept of an entire contract, which is really a common law principle, very tough in its operation, is coloured, if you like, qualified is a better term, by the concept of substantial performance. In other words, if the court is of the mind to regard this as something other than an entire contract, it's severable or it's divisible, then it may be that performance to a degree is enough to justify a party receiving some compensation, which therefore imposes an obligation on the other to ensure that some compensation is paid. And now it starts to look a little bit like equitable principles of quantum meruit and a little bit like unjust enrichment. So you'll see that some of these principles, common law and equity, they merge into each other. And sometimes it's a little hard to decipher what's what, but don't be afraid to argue in the alternative if you believe that there are good grounds to do so. Just a reminder, first and second assessments, I was pretty liberal in allowing you to argue certain things, not so much in the exam. It's got to be much more precise. So before you decide to argue in the alternative, ask yourself genuinely, can I mount an argument based on the law in relation to this alternate argument? If you don't believe you can, don't argue it. So severable or divisible contracts are those where typically there's a range of services or a supply over time where one party genuinely did receive a benefit and it can't be argued that really this person was engaged to undertake a specific entire task. So part performance comes into it as well. And when it comes to part performance, a party might be willing to accept something than full performance, even though they may have had grounds to argue that the other side had breached the obligation by not fully performing the contract. Now, here's a kicker. If a party decides that part performance is sufficient, then they cannot later claim that the contract had been breached. And it ties in then with this principle of waiver, doesn't it? Once you've committed yourself to a position, then you're generally stuck with it. The acceptance on the part of the innocent party must be voluntary for that to occur, but once the election is made, it's made genuinely. And that's very similar to the election of termination versus affirmation. Once you commit, that's it, there's no going back. Right, so when you're talking about part performance, you also need to consider substantial performance. And what's the case that, that's a bit cryptic. You might want to think about Luna Park and tramways for a number of reasons, and this is probably one that would work in that context. So generally, when it comes to substantial performance, It's based on a recognition by the courts that they're not willing to, they are willing to allow minor failures generally on full performance to be excused and not be a reason for refusal to pay the contract price. And you're probably thinking, but in Cutter and Powell, wasn't there a situation where there was failure to perform and the court said we need exact performance? And the answer is yes. One of the problems with our common law principle is that courts decide on the facts before them at the time, and what may appear to be different outcomes in similar circumstances requires some careful consideration of the facts. And also, of course, things change over time. So, for example, the Cutter and Powell principle certainly would have been the dominant way of looking at these issues at the time it was decided. But since then, it's been watered down through equity, it's been watered down through part performance, substantial performance, and other principles such as divisible contracts. I know I'm moving fast, but I hope that you're keeping up with me. And at this stage, it's really more a case of revision and identifying some of the more important parts. Now, I mentioned unjust enrichment. Does anyone know what that means? You can just say yes or a no, or you can describe it. Let's have a look at the chat facility. No votes yet. All right, so when we're talking about unjust enrichment, we're really talking about a situation where there has been substantial performance and there has been a benefit to the other side, which should be reflected in that side making some contribution or payment towards the party that technically was in breach. Another few principles that you might consider in this area of practice: tender. And when we talk about tender, we're really talking about that commitment to fulfill the terms of the contract. Often we talk about tender in the context of conveyancing contracts, where one party establishes that they were ready, willing, and able to perform by tendering at settlement. That means that they turn up at the time and place and formally make sure that they have a witness to the fact that they did have the check, they were ready to go for settlement. Also think about contingencies, and this is going back to contract A, the difference between condition precedence and condition subsequence. So that may be something that you need to distinguish in answering a legal question when it comes to terminating as a result of a contingency. So a contract may stipulate that it's subject to a contingent condition, and they can either be conditions precedent or conditions subsequent. Condition precedent basically goes to determine whether the contract comes into effect. If the condition precedent does not occur, then there's no contract, it's terminated. Condition subsequent is something where an event occurs after the contract has commenced, and if the condition subsequent does occur, then the contract is terminated. So for condition precedence, if something does not occur, the contract comes to an end. Condition subsequent, generally, if something does occur, then the contract is terminated. That's the terminology used in the notes. It's a little misleading in the sense that a condition subsequent might be, for example, subject to finance. If that doesn't occur, then, or if the answer is no, rather, it may then trigger the opportunity of a party to terminate the agreement. Now let's just have a look at a quick scenario, just a really simple scenario, to see if we're getting our heads around some of these principles. And here it is. Let's assume that you engage someone to do some work for you for the price of $100. The work is done, but it's substandard. And you then get in another person to come in and quote and they say, look, to repair this work, it's going to cost $250. So the repair work is substantially more than the original price. Is your claim based on substantial performance, or is the claim against you rather based on substantial performance likely to succeed, assuming you didn't pay the original person. There's no right or wrong answer to this, but in that particular scenario, have a look at Bolton and Mahadeva. It's in your notes at, I think, 19.175. It probably is, given the extent, the fact that it's 2.5 times the contract price to rectify the work, in those circumstances, it's probably a breach of the contract rather than any form of performance. All right, let's move on to week 7, which deals with discharge by termination, breach and repudiation. We're dealing with chapter 20. So conditions, warranties, intermediate terms, all of this you remember from contract A. Some of the key cases, again, Luna Park and tramways might be a key case. Warranties, Associated Newspapers and Banks, 1951 83 CLR 322. What was warrants? In a couple of words, can someone tell me what Associated Newspapers and Banks was all about? Comics, that's it. What was the comic character?
Was Ginger Megs, and it was placement of the comic strips.
Very good. Thank you, Tanya. And thank you, Matthew. Comics, Ginger Meg's case. So the key point there, if a warranty is breached, the contract is not treated as capable of being terminated. And that's right, Jackson, it wasn't on the front page, but it was still published. So it was a warranty in that situation. And when we talk about a breach of warranty, we're almost certainly looking at a remedy of, in a word, what remedy would apply for breach of warranty? Any thoughts?
Damages.
Damages, excellent. Thank you, Tanya. That's it. Intermediate terms, so this is the tricky part. This is where all the exam questions are based. Some of the key cases, and I'll mention a few during this evening, but one of the first one that comes to mind is Hong Kong Fur Shipping against Kawasaki Kisan Keisha. It's 1962, 2 Queen's Bench 26. So intermediate terms describe an obligation where the breach may have the effect of rendering the situation as being no contract at all, or it may be that it goes the other way and allows for damages. And all of this we need to consider in the context of this principle of repudiation. So repudiation goes beyond breaches of essential terms and serious breach of non-essential terms to deal with anticipatory breach of some sort or another. In other words, if a party exhibits, and this is the general terminology, an unwillingness or an inability to render substantial performance of the contract, or gives a clear indication that they no longer wish to be bound by the terms of that contract, then we're into the realm of repudiation. And what's a good case that you'd quote if you're considering repudiation? Any thoughts? There are a few. Rochester, yep, that's pretty close. Thank you, Natalie. I'd suggest Kumpatu. So Kumpatu Local Aboriginal Land Council against Sandpine. I've mentioned it a few times during this unit. 2007, 233 CLR 115. So when it comes to breach, there are 2 basic types of breach, aren't there? Number 1, there's a failure to perform. And number 2, there's an anticipatory breach. That is an indication that we're not going to go ahead with this contract. Where there is a failure to perform, then it's relatively straightforward. It's a simple type of breach. One party fails under the obligation, and generally the other party can take action. Anticipatory breach, a little more tricky because you need to determine what is the intention of the party and be able to back it up. But even failure to perform is still potentially tricky. As we've identified, the preliminary question is, well, it's a breach, failure to perform, so therefore it's a breach. But is it a breach of a condition or a warranty or an intermediate term? And is the intermediate term on this occasion acting like a condition, or is it acting like a warranty? Now, if the term not performed is a warranty or an intermediate term that is acting like a warranty, the parties are bound by the contract and the innocent party can seek damages. But if the term not performed is a condition, then the innocent party can terminate the contract as well as seeking damages. So there is a right to elect to terminate in those circumstances. But as we've mentioned, you've got to be careful, you've got to give it serious thought, because if the party terminating or purporting to terminate does not follow the correct procedure or does so for the wrong reason, then in turn, that might be regarded as a repudiation, and the other party might then act upon that repudiation in terminating the contract themselves. So repudiation is relatively complicated, and another case that you might consider about the concept of being ready, willing and able to perform, particularly in the context of later not being ready, willing and able to perform, as Natalie mentioned earlier, is Hochester against De La Tour. All right, so there can be repudiation, which is very clear, express. There can be repudiation by implication. And a party may be unwilling or unready or unable to complete their transactions, but they're not willing to come out and actually say that. Can anyone think of a case? I'm sorry I lost you there. I think the internet connection where I am at the moment is not very good. So just bear with me. I'm just going to check if we're recording, and we are still recording. So thank you very much for your patience. All good? All right, let's continue. So repudiation is complicated. It can be implied. Did anyone come up with the case that I was thinking of? Any thoughts? I'll see what you've been chatting about. Okay. Oh, thank you, Peter. Thank you for taking over the class, Peter. And everyone's passed. That's good. I'm sure you will anyway. Okay. And you don't need to answer that question I've posed because you all answered correctly while I was gone. All right, well, we'll move on then. The case I'm thinking of is Hammer against Barrow and Coca-Cola. Hammer and Barrow against Coca-Cola, rather, which is the New Zealand case where there was failure to perform properly in relation to what item? Thank you, Jackson. You did get it. What was the item in question? Yo-yos. Yes, Matthew. Thank you. So a party needs to be clear as to why they are repudiating. Think Lorinda against Capalaba Park. It needs to be clear in multiple circumstances. One of them might be because of substantial delay in performance. So let's take a question and see if we can put all this into some context. Let's assume we've got a lease situation. The tenant is late in paying on several occasions. The rent now is overdue. The lawyers say, for the landlord say, where is the rent? She said, I can pay later. The tenant says, I can pay later. Now, in that situation, the late payment is a breach. It's likely to be a breach only of a warranty and therefore result in a claim that's available for damages. It's unlikely that being late only to that extent could be regarded as an unwillingness to perform the contract. So a contrast in that case, particularly when it comes to leases and building contracts, a case that you might want to think about is Severable against Builders Licensing Board from 1982. Now, if you have frequent late payments of rent, it may be that it's not quite a repudiation, or it may be that it does amount to a repudiation, particularly if it's in combination with other matters. So it's a grey area. Again, the sort of thing that you get in exams. But have a think about Progressive Mailing House against Tabali, 1985. So let's assume that this lease continues on foot. The tenant has been persistently paying a little late, but getting there, and now has breached another term of the contract. For example, selling items that were not allowed to be sold in that shop under the terms of a lease. In other words, very often a lease says you can lease this premises, but only for the purpose of, having a nice creamery, for example. If they then stop doing that and open up a clothes shop, that may be a breach of the lease because it's a breach of the term. So the key question then is to determine whether we're talking about a condition, intermediate term, or warranty. Think Luna Park as an idea. And it can then build on in different situations where let's assume that there's late payment of rent on a number of occasions, despite a commitment from the tenant to keep the shop open on Sundays. The shop owner says, no, I'm not going to do that. Let's assume that the council have requisitioned the shop for a number of breaches. People have been, the tenant been putting things out on the footpath, all sorts of things. Now, when we get to that stage, it's starting to look a little like Kumpatu situation, because there are breaches that are quite significant. Arguably, they go to the basis of the contract. Individually, they may not amount to a condition of the contract, but it may be that there's sufficient there to warrant regarding the tenant as repudiating the lease to justify the termination. All right, so all good. Let's move on to week 8, frustration. So when something unexpected occurs that could potentially put the entire contract to an end through termination. A case that you might want to think about. What's the case that comes to mind with frustration? Any thoughts? Very good, Jackson. That was quick. You were waiting for that, weren't you? Cadelpha. Very good. So Cadelpha Construction against State Rail Authority of New South Wales, 1982, 149 CLR. So when we talk about a frustration, we're talking about a frustrating event, aren't we? So in order for there to be frustration, there must be a frustrating event, and it's got to be unforeseen, it's got to be outside the control of the parties, and the third element, it must fundamentally change the environment in which the contract was supposed to operate. Now, the frustrating event might be of two types. It might have the effect of making the contract impossible to carry out, or it might make the obligations might be able to continue, but deprive them of any real meaning or benefit. So it's that second one, the grey area, that is the sort of thing that it's more likely to be examined on. So it seems very broad, doesn't it? And you'd think based on that, that it would be relatively easy to avoid contracts alleging frustration, but it doesn't work like that in practice. In reality, there needs to be something reasonably substantial to justify a successful argument based on frustration. So the next thing is the question of whether a contract or not is frustrated determined by a court or a tribunal as a question of law or a question of fact? Theoretically, strictly. Law or fact? One vote for fact. Lots of votes for fact. It's a bit of a trick question, this one, because in my view, it's technically a conclusion of law However, in order to come to the conclusion of law, the court or tribunal needs to look very carefully at the facts. So it really is a combination of the two. So it means it's consideration of whether a contract is frustrated or not means considering the terms of the contract. It's a legal issue, therefore, technically it's a question of law, but ultimately, in reality, it's a mixed question of both law and fact, as most of them are. So if you're looking at answering a question in frustration, you need to consider the terms and then of the contract. Then you need to consider statutory interpretation and construction, and ultimately decide whether the circumstance justifies invoking that doctrine. So treat cases in the past with some care. Every case in frustration is determined on its own merits. So frustration does have some similarities with common mistake, doesn't it? Frustration is closely aligned to common mistake. So think Codelpha, as Jackson would remind us, but there are some differences. Mistake relates to circumstances at the time of the agreement, doesn't it? Whereas frustration is some future occurrence. And that's really the key difference. So if you have a question based on frustration and you're arguing common mistake, then you've probably overlooked that preliminary matter, which means that you probably won't score very well in an examination context. So mistake renders contracts void or voidable, but with frustration, the contract is discharged as to future only. And mistakes as to the existence of the subject may lead to liability and damages. Think McRae against the Commonwealth Disposals Commission. But if the subject matter of the contract perishes without fault, then both parties might be discharged without breach. Think Taylor and Caldwell. Taylor and Caldwell was in 1863. It's a very old case. We get a few of those. What was the key issue? What was that about? Taylor and Caldwell. The facts related to what? That's it, Gareth. Very good. The music hall burning down. So that's another key case that you might want to consider in the context of frustration. Also, the common law position, as we've discussed, it may be altered by statute. Think the Sale of Goods Act in Queensland, Section 10, which deals with the specific issue of goods perishing before sale. Now, it may be that the contemplated method of performance is not possible anymore, which is the second way that the contract might be performed or might be frustrated. And here we get into arguments in relation to generally an increased burden in performance. So think the Eugenia case from 1964, which is ocean tramp tankers against SOVFRACHT, but commonly known as the Eugenia, 1964, 2QB 226. So just a quick question on this one. Let's assume that you've got a business where you charge a fixed fee of, say, $100 to take passengers from an airport to the CBD. But there's some event occurs, some natural catastrophe, which leads to a blockage of some of the arterial roads. And what it means is it now takes you twice as long and it's nearly twice as expensive for you to have the passengers taken there. Would the difference as a result of that be such as to frustrate the contract? We have one vote from Tanya. Any other votes? Good. Yep. No. Peter reminded us it's like the case involving the Suez Canal. Absolutely. So no, in that situation. It's certainly more onerous. It's more expensive to fulfill. But what's the key point with this? Why isn't it frustrated? In a single phrase, can anyone tell me why that would not be a frustration? Inconvenience, yes, but that's not the legal test, but it is, you're right. What's the key legal phrase And this is where I come back to the issue that frustration is a question of law, not fact, technically speaking. What's the key legal phrase as to why that contract situation is not frustration? I'll have to count you down on this one if we don't get an answer soon. Incapable of being performed? Well, that's a good effort, Gareth, but I think it's still capable of being performed because you can go around the problem. Any other thoughts? The answer that I'm looking for, and you can tell me if you think I'm wrong, is Natalie said the event isn't one of the categories of frustration. Close. The key thing that I was looking for is that you're stuck with the additional expense and obligation because this is not radically different to the original undertaking. So that phrase, is it radically different from the original undertaking? And you can consider the Eugenia case in that regard. All right, let's move on to week 9 remedies, chapter 23 of your text. So damages, of course, is the key remedy. That's the one we should think about first up. Damages are a form of compensation, not a form of punishment. Remember that there's issues around remoteness, so it's a little bit like torts, but the test of remoteness in contract is narrower than it is in tort. And remember also the statute of limitations. So if you're thinking in terms of providing in an answer assumptions, and there's no dates mentioned, and you might want to at least make a statement that it's within the limitation period, or better still, it's within 6 years and therefore within the limitation period. When it comes to damages as a remedy, we need to commonly think about expectation damages. It may be that a party has not just incurred expense, but more importantly, potentially, is they've lost the gain that they'd anticipated making. And we talked about Zarnico and Kufos, 1969, 1AC 350. So causation, what must be compensated? We think about the but-for breach test. Compensate for the actual loss suffered and the loss of expectation under the contract. So there are two ways in which both the law of contract and the law of torts might affect a defendant in their responsibility, and it's to do with causation, and it's to do with remoteness. So what's the rule? What's the rule that came from a case that governs the law of remoteness of damages in contract? This is one that you'd really need to cite whenever you're talking about damages in contract. The rule in, very good, Natalie, Hadley and Baxendale. It's a very old case, as many of them are, 1854, and in that instance, the court decided at an early stage that the plaintiff can recover damages as are fairly and reasonably to be considered, either as arising naturally, that is in accordance with the natural course of things, from the breach of contract itself, or as may be reasonably supposed to have been within the contemplation at the time the parties made the contract and as a probable result of the breach of it. So in Hadley and Baxendale, we have the famous two limbs. Number one, the defendant should be liable for damages occurring naturally according to the usual course of things. And second is liable for damages that might be reasonably supposed to have been within the contemplation of the parties at the time they made the contract and is a probable result of a breach of it. Okay, so Hadley and Baxendale, ingrain that in your head when it comes to any claim for compensation, damages for breach of contract. And think about the two limbs. So the first limb, it's got to be within the usual course of things and cannot be So that which was not supposed to have been in the contemplation of both parties will not necessarily be compensable under that first limb. When you think about the second limb and you're thinking about causation, then there's a case of Victoria Laundry against Newman Industries, 1949 2 QB, KB, King's Bench 528 that you might think about. All right, so when you're thinking about damages, you might also want to consider contributory negligence. And where we talk about contributory negligence, we're saying there should be an appropriate reduction in damages based on the contribution of the other party to it. All right, so let's take a little case example. Let's assume that somebody wants to sell 1,000 kilos of oranges to a wholesaler. So a farmer has a deal, $2 a kilo for 1,000 kilos of oranges. The day they're due to be delivered, the wholesaler says, sorry, I don't need the oranges anymore. We overestimated consumer demand. The farmer is, of course, furious. Everything is damaged or packed up, ready to go. And so what does the farmer do? Calls off the delivery and says, dump the oranges in the tip. So can the farmer claim damages in those circumstances? And does the farmer have any problems associated with the claim? Any thoughts?
I would say he can, but he would have to try and mitigate rather than just dumping if he could sell them.
Very good. So what's the basis of the claim in damages? What's a word that describes initially the type of damages being sought? Because it was something that was going to occur in the future, we'd probably think about them as expectation damages, weren't we? So think about that. So in terms of expectation, the farmer expected to receive $2,000. Now, you're right, Tanya. The wholesaler would probably say, but you've got a duty to mitigate. In that situation, are there any practical issues that may come into play? I guess one of them is, what do you do with 1,000 kilos of oranges that are just about ready to go off? In other words, it's not necessarily easy to find an alternative. So just because a party might, for example, destroy the subject matter, it really is a matter of considering from a practical perspective what they could have done about it. And perishable items is of particular concern. Let's move on to the final week 10, remedies, restitution, equity, section 18, ACL. So we only did this 2 weeks ago, so this is all pretty fresh in your mind. Equity follows the law. Equitable remedies are discretionary. Remember that basic threshold question. Does the party that is wronged seek to terminate, or does that party seek to affirm? Does the party terminate or does the party rescind? From a technical perspective, you remember that rescission applies to the coming to an end of contracts as a result of vitiating factors, such as misrepresentation or mistake, whereas termination arises in circumstances where there has been a breach. And of course, it brings in that whole thing, is it a breach of essential term, a non-essential term, intermediate term, etc. So make sure that you have a clear understanding of termination or affirmation, and a clear understanding of termination or rescission, and understand repudiation and when these things can come into play. In terms of repudiation, a good case to consider, I mentioned Compatu earlier, but another one, and I've mentioned this tonight and a few other times, is Cheval Builders Licensing Board, 1982 149 CLR 620. When it comes to conveyancing real estate contracts, remember that generally time is of the essence, and a good case to think about there is Legione and Hartley, 1983 152 CLR 406. And from a practical perspective, it's all very well to talk about common law damages, but in reality, the ACL is the important place to look You remember section 236 and some of the ancillary provisions in and around 236 that provide the basis for relief in damages under the ACL. And remember, of course, that when it comes to the ACL, the court has very wide-ranging power to order discretionary relief in circumstances where someone has suffered or is likely to suffer damage as a result of a contravention of the Act. So let's just take a very simple scenario. You're representing a client who was a passenger on a tour bus and paid in advance. It was supposed to be 14 days. 10 days into the tour, the bus is written off in a serious accident. The remainder has to be cancelled. Your client is physically unharmed, but wants to know if he can claim damages for the entirety of what he's paid. Now, this is similar to Baltic Shipping and Dillon. There's not a complete failure of consideration for payment. 10 days has already elapsed and the contract has not failed to materialise. It's materialised. It just wasn't fulfilled. So in that case, probably damages would be to an extent rather than for the full amount. And that brings me to the end of the overview commentary of the specific content in the unit. Are there any questions arising from any of that? You've been very patient. All good? All right. Just a few things for the exam now. When it comes to the exam, stay calm. Do try to identify the material facts if it's a problem-solving question, and of course then the relevant legal issues, and go through the IRAC process, but don't slavishly go through IRAC process. We all know what I mean by that, don't we? Issues, rule, application, conclusion. So think in terms of that, but don't necessarily use those as headings. And when you're considering a problem-solving question, you may have to consider statutory interpretation. You may have to understand the relationship between the statute and the case law. Remember, of course, the jurisdictional issue. It may be Commonwealth, it may be state, it may be a combination of the two. Remember some of the basic questions and the need to state assumptions or to identify that which is clearly important but missing in the question. So call the lecturer on that and say, you haven't told me about this and it's important. You can then say, if this is the scenario, here's my answer. If not, here is my answer. So when it comes to identifying the rules and applying the rules, remember some of your legal logic issues and things like making sure that you use inductive reasoning or deductive reasoning as the case may be. Now, I know that's all very quick and we're right down to the end of the unit now. But when it comes to you in the exam, having formulated all your thoughts and you're ready to start writing, that's where you need to be very careful. Avoid, if you can, that which is too wordy or redundant. Avoid, if you can, that which is legalese or inclusive of lawyerisms, if you like, and avoid something that's poorly organised. So you can ensure that you write using the active voice if possible. The active voice is good because it has a clear subject which makes the action happen, doesn't it? It's focused, it's definite, and it forces the writer to commit what they're writing, and that's where it's easier for the reader. So rather than saying something, it was understood that such and such, say Jim understood that, or Mary understood that. Do you understand what I'm saying? All right, so be as clear as you can in that regard. In terms of the grades, it's straight 50% for the entire unit. So provided you get over 50%, then you will pass, even though you may have failed individual components of it. And I think that's all that I really want to say before we finish the unit. I will just ask for you please to provide feedback. If you have not yet hit the big red button to have your say, please do so. All right, any questions then about the content tonight, the content about the unit, or the examination? Are we all good to go? I think we are. All right. Well, it's been a pleasure to take this unit. I've got to say, this cohort has got some talent in it. So please keep talking to each other throughout your university studies and learn from each other and try to encourage each other, because I'm sure you'll all do very well. Many of you will do very well. All right, all the best, and thank you very much. We'll see you next time. Bye.
Thanks, John.
Bye.